Hi Doris, my name is Cynthia Villanueva and I am the lawyer assigned to your recent request for legal advice. I specialize in employment law in the state of New York and I'm here to answer any questions that you have. So before we go any further, I would like to discuss the details of the situation you have going on at your workplace right now. I understand that you recently found out one of your employees is pregnant and that she has developed a medical condition known as preeclampsia, and she's needing to go on a pregnancy leave immediately. She has applied for FMLA because she believes she is eligible, correct? Okay. So now that we have all the details, here are a couple of things we need to discuss. The first one is FMLA. Or the Family Medical Leave Act, and the second one is PDA, or the Pregnancy Discrimination Act. So let's begin with FMLA. FMLA is a law that allows any employee to take unpaid job protected leave for a specific family or medical reason. It states that the employee must have worked with the employer for at least a year and that it has worked 1,250 hours within that year. Okay, this law also states that the employer must have at least 50 employees. And I understand that your employer only has 47 employers at the time. So therefore, this law automatically disqualifies your employee from FMLA. Now, this law states that you must treat this employee like you have any other employee that had to take leave for a medical condition, okay? This means that if you have granted FMLA in the past, then you must do the same for her. Now, let's move on to PDA, or the Pregnancy Discrimination Act. This law protects all pregnant women and forbids discrimination based on pregnancy when it comes to any aspect of employee, including firing or benefits such as leave and health insurance. Based on the information I have provided you, my recommendation to you as your lawyer is that, first of all, you do not terminate your employee based on her pregnancy. And that if she needs to take the leave of absence because even though your employee is not covered through FMLA, she is covered through the PDA. Okay, so I would recommend that you grant your employee with the leave that her physician deems necessary. This will provide your employee with the peace of mind and will let her take care of her pregnancy, and this will also protect you as the employee, but as the employer, by not terminating her, which may result in a lawsuit for violating her rights. Because this medical condition is also recognized as a disability based on the ADA, or the Americans with Disabilities Act, then you must know that you as the employer must make reasonable accommodations for her disability. I also recommend that you, along with your HR department, can take this time to look over your employee handbook and detail any leave of absence, so that if at any point in time you run into another case similar to this one, you and your employer know or have a clear understanding of what steps you need to take. I hope this has answered all of your questions for now, and it was nice talking to you, Doris. Thank you. Bye now.